Okay, my friends, I thought of sharing three very recent developments with you. They are Belgian, as my country is, but they all relate also to the European Union, and therefore I thought they might generate some more general interest. Dull themes, I must say. The first is on price advertising of supermarkets containing errors, many errors. The background is that price advertisements are treated extremely liberal in Europe. Basket advertisements can't contain many errors, as the European Court of Justice has also set by precedents. And this is a matter here that falls a little bit under that very general lenient attitude towards weekly basket of your purchases advertisements in supermarkets. It is a matter that came in September to the Supreme Court. The Belgian Supreme Court is called the Cassation Court. And it was also an advertising with many errors. That was conceded. That was not any of the problem or the discussion, but the French supermarket Carrefour, who was comparing its prices with competing supermarkets in the same geographical area, found that these errors were not sufficient to simply conclude that the advertising was to be banned, because as long, and we all know the elements, material elements are compared, relevant elements, verifiable and representative features, and it's explicitly added there that this includes the price, the comparative advertising should be stimulated, is good for everybody. The Brussels Court of Appeal did not follow this and said, no, this is not an objective way of comparing prices if you have so manifold errors. And Carrefour said, no, we go to the Supreme Court and we ask that court even to request a preliminary ruling with the European Court of Justice. This has to be clarified because consumers are here not misled, and this has not been examined at all. And Carrefour relied on the directive that is applicable in that respect. A recital in that directive that it found is that we should see whether the consumer behavior can be influenced or can be affected by this way of advertising. No, said the Supreme Court, I refer to the existing case law. It's not necessary. And I listed there the famous precedents of Lidl versus Colruyt and L'Oréal, Belure, which is known, of course, in the trademark area, but is also valid here, that you need to compare not only these features that we enumerated, but it has to be done in an objective manner. Conclusion is that the fact of yes or not misleading is not longer relevant to be substantiated. A second development that I wanted to share with you is one on anticipated regulatory changes. The first one is on the blackout sales, pre-sales period regulation, and the other one is on seller's warranty. The first one is on the blackout pre-sales period, or the blocked periods. We have that in every season in Belgium. There's twice a year, a month that no price advertisement or announcement suggesting reductions can be made. The Court of Justice had already held before that this was impossible to uphold, and that it had to disappear, just like our general prohibition of sales at a loss. And this has been this came again recently before the Supreme Court, and that was further substantiated there that the general prohibitions of announcing price reductions can no longer be applied in light of the European directive. As a closing point, the time is running out. We know that in Europe, almost everybody knows here, that you have the mandatory warranty of 24 months on consumer goods. But in fact, in many countries, it is very important to see whether the defect was flagged within 6 months following the delivery or not. And we know that there is there are plans to extend this. Yes, I know that time is running out. Time to to extend that period of 6 months where the presumption exists that the good was indeed not in conformity with the good actually, or the product actually purchased, that this is now extended to 24 months. This is a very important change, of course, for sellers in terms of the proof, the shifting of the proof. And this in Belgium will count for every sale, even if it is not a distant sale. This is different in the proposed directive, the upcoming directive on goods, which will probably only be valid or have as ambit the distant sales and even the online sales. In Belgium it will probably be more strict than in the other European countries. Thank you.